Okay, hi. I won't be very long because we've got a lot to pack in. The format of this keynote is going to be a very brief introduction, then Deirdre, rather like yesterday, is going to talk for about 35 minutes. Then we're going to have a little bit of response from me and back and forth, hopefully for not much more than 10 minutes, leaving a good 10 to 15 minutes for questions, we hope, okay? So this is a law keynote. Deirdre is an amazing person to be delivering this keynote. She has a very long and illustrious track record in this field, in technology law, in civic rights, in digital rights, as well as in academic work. She came really to my attention, has really infused my own work with her work on privacy on the ground, where she actually looked not just at the format of the law, its formal aspects, in different countries, but how it actually was implemented by practitioners in different countries, including in the US and various countries in Europe. And that was really groundbreaking, hence privacy on the ground. So Deirdre is going to speak about a lot of things, but I think primarily about whether administrative law can give us means to exert democratic control over the operation of public tasks using predominantly private sector algorithmic tools, which is a very crucial area. Okay.
So first, I of course want to thank Dana and Jamie and Alexandra and Fernando for inviting me to speak today. It's a real honor. This is my favorite kind of conference because I moved from a law school where you have both feet firmly in one discipline, to the UC Berkeley School of Information, precisely because I think that solving big problems in the world require us to pull from different disciplines and different ways of looking at problems, and to not just do our research in some sort of parallel play, but to have places like this that help us come together and actually figure out how we can collaborate and collectively advance the sort of society that we want to build. So, as you know from the title of this talk, we're all aware, and we're part of a community that has been pulling algorithmic systems kind of out into the light and deconstructing them and interrogating them to understand what values and biases they embed, and to point out their inattention to culture and context. But this morning, and not just because I'm a lawyer, but because I've spent a lot of time working with people in the technical community who've built tools for security or built tools for privacy, who then sit there and say, why doesn't anybody use them, right? And it's because we care about incentives, right? And so this morning, I want to shift our perspective away from questions about the ethical obligations of engineers who are designing systems or of the private companies that are building them, and ask some questions about incentives. For surely the people who are procuring these systems in the public sector and the people who are using them share some responsibility for the values gaps and the lapses in these algorithmic systems. And what I want to suggest is that no matter what processes, methods, tools are developed in this community to help us reason about when algorithmic systems are a good choice or a poor choice, or the cool tools we might develop to actually build values into technical systems, are all going to stay in rooms like this unless we actually do some work to align the incentives in the external world to foster cultures of algorithmic responsibility. So this morning I'm going to propose two interventions that I think could do just that, at least in the public sector. So I thought we would start at the top. Many of you probably recognize this as the Supreme Court. And our story starts here. It also starts at somewhat of the end. And I don't know if anybody has said Eric Loomis's name. Maybe that's like blockchain in this room. I don't know. But I'm going to say both Eric Loomis and Contestability, right? So we're gonna start here because it's at the end of Eric Loomis's legal battle with the state of Wisconsin over a judge's use of a Compass risk assessment tool during his sentencing. Mr. Loomis had raised two challenges under the Due Process Clause. I know this room knows this probably very well. It's probably one of the few Supreme Court decisions you've read. But one was challenging the secrecy of the underlying algorithm, and the other was actually challenging the algorithm's use of gender. And I want to focus on the issue of gender just briefly. It's not the center of this talk, but there was a dispute below about how gender was used. Loomis had argued that gender was used as a criminogenic factor, right? Something that was actually used to determine his sentence, producing, he thought, higher risk scores for men like him. Wisconsin, on the other hand, contended that gender was only used for statistical norming. And I think my understanding is this refers to what North Point calls their scale sets, right? The idea that we were going to treat men and women differently. And how gender is used in this system matters, right? It matters for the outputs, it matters from a legal perspective. But that's not actually the focus of my talk. The focus of my talk is this sentence in yellow here. So this case went all the way up to the Supreme Court almost, right? Eric Loomis petitioned the Supreme Court to take the case, and the Solicitor General, who represents the United States government in cases before the Supreme Court, was asked for its opinion about whether or not the Supreme Court should hear this case. And these are the words that they wrote, right? That this is a serious constitutional question. However, this case is not a suitable vehicle initially because it's unclear how Compass accounts for gender. Now, as a lawyer, this is a place where you like audibly suck in your breath or you kind of spit your food across the room, right? So we adopted an algorithmic system for determining risk into the system that is supposed to mete out justice in the state of Wisconsin, and we don't have clarity about how gender is used. Like, does that strike any of you as problematic? Okay, well, surely this is a policy decision, right? This isn't like a mere implementation detail. And the fact that this decision was not clear all the way through the court proceeding is a highly problematic when we think about democratic process, right? Okay. Now, one could say, oh, well, that's just, one edge case. This can't possibly be happening all the time. But actually, no, inattention to values appears to be the norm. So this is a quote from some lovely work by Broadus and Goodman. They did an open records request seeking information about 6 different kinds of algorithmic programs from 42 different agencies in 23 states. And only one jurisdiction provided the algorithm and details about its development. In most instances, what Broadus and Goodman reported was that agency documents revealed that they did not have access to the algorithm or the processes through which it was generated or adjusted. People couldn't produce records about design choices, data selection, factor weighting, validating designs. They didn't even have records about what problems the models were trying to solve. Are you weeping yet? Like, you should be weeping, right? Okay. So what sort of policy implications are embedded in some of these design decisions? Well, I think this room knows pretty well, but I just want to look at some of them. So we have assumptions and optimizations. This is one of my favorite, very old cases. In 2002, the USDA disqualified several grocery stores serving predominantly Muslim East African communities from accepting federal food stamps. This meant that a whole bunch of people who were eligible to use food stamps to buy their food couldn't get the halal meat that they're required to eat in order to observe their religious requirements, right? And why? Well, the agency said a careful analysis had revealed transactions that established a clear and repetitive pattern of unusual, irregular, and/or inexplicable activity for your type of store. The agency had all this data because we'd moved to a system of electronics benefit transfers, and so they're mining all this information, looking for interesting patterns. Now, in identifying these particular grocery stores as engaging in fraudulent patterns, they of course had an assumption right here that the target of fraud was going to manifest similarly across all groups, right? And it turns out that assumptions of normal behavior that you might look at for identifying fraud, things such as large bulk purchases, round number purchases, as in like cashing out your whole check, etc., were really not at all the normal patterns of purchasing in this particular community, where people go and shop in groups. They have limited access to cars, so all the women in a community might go shop at the same time. They have a custom of actually asking for things in dollar amounts. I'll have $10 worth of meat, not I'll have 3 pounds of meat that you might add, right? And so patterns that might look anomalous if you look at the whole population, in this particular subset, the optimization suggesting that there was fraud was like manifest in a similar way in these more marginal populations, just produced this output. We've had many discussions about operationalizing of target variables, right? And the idea of how we actually develop a proxy for what it is that we actually think we want to measure in systems, for example, where we may end up, instead of measuring criminality, we're actually end up measuring arrests, right? This again, a deeply embedded policy decision. One of my favorites, a choice of model. For example, some of the predictive policing technologies that try to model crime do so by analogy. Some of the algorithms have been developed to model infectious disease. Some of them have been modeled based on earthquake patterns. Now, I don't know enough about how crime spreads. There are many theories, but I do know that choosing a model is a significant policy decision, and one would want it to relate to your theory of crime, right? So these are like key questions that agencies are not paying attention to. And most recently, we all saw this issue of thresholds, right? So Amazon's recognition out of the box with its default 80% threshold, that doesn't have any particular relation or relevance to the domains in which it was being used. And this threshold of 80%, right, implicitly makes a policy decision about the trade-offs between false positives and false negatives. This is something that agencies should be reasoning about, right? It shouldn't be a default that's set in a product that one onboards. Yes, it was configurable, but it was buried on page 131 of Amazon's 433-page system with some advice that if you were using it in the law enforcement sector, you might choose a 99% threshold. Maybe, but who shouldn't be making that decision, and with what sorts of information? So why is this happening? Well, perhaps it's a failure to learn from the past. I imagine that Morgan Ames yesterday in her presentation on values and design and technical systems put up a picture similar to this. I could be wrong, but this is one of Robert Moses's bridges. It's a canonical example of the ways in which architecture, the built environment, it could be technically built or physically built with bricks and mortar out in the world, have implications for values. In this particular instance, while it's a matter of some historical debate, these bridges were built at the behest of Robert Moses, who was a very famous New York City planner, and they had the effect of keeping buses, and therefore the poor people who used them, from enjoying the benefits of the public beaches that are all over the coast of Long Island. The importance of architecture as a method of making values real is in part in the way in which they both make them real and bury them at the same time, right? These bridges do not broadcast their politics. There was an article just a few weeks ago reminding people again of the perhaps sordid history of the intent of having bridges through which the public buses cannot go. They just quietly impose physical barriers and transaction costs, having the similar effect of saying poor people stay out. Yet over time, their political ends actually disappear. So it could be that we just haven't learned from this past. What I want to suggest, though, is that law has a lot to do with it. In particular, procurement law. Agencies appear to be largely acquiring these systems through procurement processes. In many instances, almost as though they are commercial off-the-shelf products, like buying a computer, a printer, some cleaning equipment. So they're using this process that agencies have to acquire goods and services to help them do their work, without actually realizing that what is embedded in this system includes numerous policy decisions. However, there's a second reason in law why I think this may be occurring. It's that even if they realize that there may be some important policy decisions embedded in the systems, agencies may well believe that they fall within some specific exceptions to administrative law. I'm going to talk primarily about the Administrative Procedures Act, which is the federal law, but I'm going to talk in generalities because as a general matter, we believe that policy that's made by agencies, whether it's at the federal level, the state level, or the local level, should abide by the same set of kind of governance norms. So you can take this as kind of a more general statement. Okay, so why does this matter, this choice between like procurement and policymaking? Well, they have very different objectives and concerns, right? When agencies are using their procurement tool to acquire these systems, they're concerned about making sure that there isn't cronyism and graft, right? They want to make sure there's fairness in the bidding process. They want to make sure that the public gets the right bang for their buck. They're concerned about transparency, about the contract terms, and they're also concerned about innovation and competition. On the other side, policymaking is something that agencies engage in. Now, for those of you, well, this is part of law, I think, at a kind of general level, but I am talking primarily about US law. I'll leave some of Lilian to bring in Europe. When agencies engage in policymaking, we have a whole bunch of procedural rules and substantive rules that guide the way in which they do that. And it's because agencies are staffed by people who are not elected, right? We have them because we believe we need agencies as our country has gotten larger, our regulations have gotten more dense and thick, because it is an efficient and effective way to operationalize the law. Congress just doesn't have enough time to get into the details and give us the fine-grained requirements in every sector of the economy. So we create these agencies and give them authority to help apply the law. Sorry. But because they are outside the normal constraints that we use to hold political officials accountable, primarily they're not subject to ouster by the vote, we restrict the way in which they go about making these rules that help interpret the law, and we require them to do it transparently, with public participation, with adequate expertise, both their own and from the external world, and to make decisions through a reasonable, deliberative process. So, right now, what we see is an absence of democratic process. These systems are being brought in, they embed all sorts of normative decisions that affect substantive interests of citizens, choices that we normally require agencies to make through policy processes. But because they're coming in through this procurement avenue, there's no agency or outside expertise beyond that of the vendor. There is no to little public participation. There appears from the Broadus and Goodman research to be no reasoned deliberation, or it would seem at least records of deliberation at all, and no factual record to understand how agencies are making the choices they're making. So, what can we do about it? Well, I want to propose two different interventions, and the reason I'm at the School of Information and like to be in places like this, as I said, is I think we need to work these things from multiple ends. One of these is about law, and the other really is about design. So on the front end, sorry, it's not as though math and models and formulas are kind of automatically viewed as things that don't have policy embedded in them, right? That there's case law on the books that recognize that the math within systems, the formulas that are developed to allocate substantive benefits from the government, et cetera, can impact substantive rights, right? And so going back several years, the taxpayer's advocate, which is a special group within the IRS, actually pointed out that policies that were embedded in IRS systems were not going through the same stringent vetting and review process as written instructions or policies, right? So we know both that there can be policies in these formulas and systems, and there is case law that suggests that just because it's math, we don't just look away, right? It's not just an implementation detail. Two, the DC Circuit, which is the court with the greatest focus on administrative law at the federal level, they've both developed a really extensive doctrine regarding what types of agency actions might fall under the exemptions to 553, which are the general rules requiring transparency, public participation, expertise, et cetera, that are designed to allow agencies to kind of adopt general statements of policy or specific rules that help them implement the task Congress has given them without touching on kind of the substantive rights that are implicated in the regulatory structure. However, in articulating and trying to make sure that that exception to the normal rulemaking processes, these normal demands for transparency and oversight and accountability, are not gutted through this rule, where agencies actually constrain themselves through making a policy statement, for example, or adopting a formula, those sorts of internal actions that normally would not have had to go through a transparent process on the front end may end up becoming subject to a rulemaking. Well, and why is this? Well, if an agency, for example, starts doing things that set a threshold and say we're only going to, the threshold for a toxin is going to be X, and we're only going to go after and engage in enforcement actions wherein industry is emitting a certain level of toxin, for example. While that may only be guidance to the affected policies, if the agency then goes to take action, it's going to find itself in an awkward position if it's acting in a way that's inconsistent with that policy statement. So where the agency has actually constrained itself and its decision-making, something that it might have had the discretion to do, might all of a sudden become subject to rulemaking because it's become more hardened and specific and will be used to bind the agency in its own actions. So this seems quite relevant, right? Given research, we know that technical systems can de-skill employees. We know that there is automation bias, right? And so by adopting technical systems, it may actually reduce the discretion of agency employees. Angel Christian's work, I think, provides a really interesting example of the ways in which a technical system can constrain agency employees, in that she found people who were working with risk recidivism software would tinker with the inputs, right, to try to get the results they wanted. And why is that important? Well, they couldn't actually kind of question or raise issues about the rules themselves, right, because they were baked into the system that they had to use. And so, constrained by the system, they were trying to tinker with the data they put into it, right? So I think that there's some sense that technical systems impose limits on agency employee discretion in a routine way, Finally, regardless whether an agency has gone through a policy-making process or it's acting under exceptions, agency action still cannot be what's called arbitrary and capricious. So, what does arbitrary and capricious means? Well, under the APA, again, federal law, courts hold unlawful and set aside actions that are arbitrary and capricious. And when they're looking at whether an action is arbitrary and capricious under the standard, what they're looking for is reasoned analysis, right? So they want to see that an agency examined relevant data. They want to see that an agency articulated satisfactory explanations for its actions. They want to see that there's a rational connection between the facts that the agency found and the choices that they made. In contrast, if they see a record where they entirely fail to consider an important aspect of the problem, for example, or they offered an explanation for a decision that ran counter to the evidence, then it will be viewed as arbitrary and capricious. Well, if we go back to the Broadus and Goodman findings, where they concluded part of their research by saying prediction models are often built and used without key policy decisions ever having been articulated, justified, or recorded, I would suggest that that looks very much like the sort of arbitrary and capricious behavior that the law is designed to make sure agencies don't engage in. So, what goals should agencies adopt when they're pulling or onboarding machine learning systems? Administrative law gives us some great guidance, right? We need to have expert input, we need public participation, we need robust deliberation. Something that's come up in the conference yesterday and I think is very important is we need assessments over time. Often when we think about making policy, we believe that there's policy making and then it's finished and then there's implementation. And when we're thinking about machine learning systems where the rules may be evolving over time, that's surely a poor match, right? That we actually need to be thinking both of the system is not just the technical components, but the data, because the training data is basically a key component of the system. And we also need to make sure that whatever processes we have don't view policy as occurring at point A, that they understand that we need ongoing assessment. And finally, I want to suggest that they should be looking to make sure that machine learning systems have contestable design. And what I mean by this is designs, system interfaces that publicize value significant parameters and settings and assist end users in understanding and selecting them. And I'm going to talk about that a little bit more in a second. So on the law side, what are the options? Well, notice and comment in some cases is going to be required, right? That there may be some instances where an agency has engaged in an action, they've developed an internal policy, they've adopted a technical system, and it constrains them in such a way that a court that's reviewing it would say, no, actually that system has so limited your discretion as an agency that it needs to go through a notice and comment rulemaking process. And I'm happy to talk a little bit more about what that means. But there are multiple ways that agencies, I think, could satisfy the requirements in the arbitrary and capricious formulation, right? Where they could establish facts, gather expertise, engage in reasoned deliberation to get good answers that would not rise to the level of a full-blown notice and comment proceeding or even a negotiated rulemaking. Again, something I'm happy to talk about in questions if you're interested. And these might include things such as impact assessments. We already see agencies required to use privacy impact assessments at the federal level. There's a push for human rights impact assessments. At the local level, we see a move to put surveillance technologies through impact assessments. And more recently, there's a lot of conversation about whether or not there might be tools that we can use to do impacts, values assessments of algorithms specifically. So that might be one way that an agency could show that it had engaged in the right kind of deliberation. Two, it could have internal procedures to attend to embedded policies. I mentioned the IRS earlier, and the IRS actually has a system that manages lots of the changes and the connection between their policy rules and the designs of their technical systems. They have some specialized staff, and they go through some specialized processes. It's an internal process. It's not fully open to the world, but it does, again, show expertise, deliberation, and fact-finding. Agencies could bring in internal experts. The taxpayer advocate is a particular kind of ombudsman. In federal agencies, we have chief privacy officers. It could be that the chief information officer plays an increasingly important role in providing expertise on these sorts of systems. We could adopt consultation requirements. We could require agencies to consult with other agencies that might have similar experiences. We could require them to consult with agencies within the government with particular kinds of expertise. We could use advisory committees. FACA is the Federal Advisory Committee Act. It allows agencies to convene groups of experts to provide them with advice. Agencies often do this when there is something that is technical and they don't feel like they have the right expertise. One could imagine an agency that was considering the adoption of an algorithmic system into its work practices. They might want to convene a set of experts from a community like this to help them think about the design choices and how they matched up with the policy commitments of the agency. Finally, they could bolster and use government expertise external to the agency. And in the US, during the Obama administration, we saw the creation of two entities. One is the US Digital Service, and the other is 18F, which is part of the General Services Administration. Both of these provide technical expertise for agencies all across the government, and they try to do it in a way that helps agencies not all have to learn on their own, but to have they're kind of like a skunk's works, right? And I think given the vast number of agencies that machine learning systems are going to affect, this might be exactly the right sort of strategy for building up government expertise. Okay. I'm so sorry I'm losing my voice. So I want to talk a little bit more about expertise, just to look at three different models. Internal expertise, if we look at the National Highway Transportation Safety Administration's, their autonomous vehicle policy document, they talk about both bringing in more technical experts, particularly on issues like security. They also, though, talked about creating an advisory committee of outside experts, right? So in the context of a policy, a regulatory activity that's going to require the agency to understand stuff that has not been core to their mission, lots of safety engineers, not lots of security people, right? They're using a dual strategy of bolstering internal and creating some external expertise to help them get over the hump. The Federal Trade Commission has for years now been developing its own expertise internally by hiring chief technology officers and additional technology officers so that they can understand the systems that they're supposed to regulate. Advisory committees, NHTSA isn't the only one. I wanted to point out at the state level, California, when it was grappling with direct record electronic voting, one of the things that the Secretary of State did there was convene an expert panel that could advise the Secretary of State on those systems. It was an incredibly important use of the academic community, and was incredibly influential in that California ended up being one of the states that did a whole top-to-bottom review of technical systems. And but for the convening of that expert advisory panel, I don't think that would have happened. Lastly, I mentioned this centralized government expertise. And in particular, I wanted to point to something like the U.S. Digital Services U.S. Web Design System. It's a really nice effort to try to standardize the development process and the tools that are used in web design across the federal government. And I can imagine the value of something like the USDS taking the insights from a community like this and trying to package them and provide them to agencies all across the federal government. We would get an enormous bang for our buck. Okay, so in my last minute and a half, maybe I'll take 2 or 3, I want to talk about this last issue about designing for governance. So one of the things that we want to be concerned with is not just kind of understanding and getting the policies that are embedded in these systems right at design time, but we also want to make sure that the people within public agencies who are there because we thought it was important to have expertise, right, are not de-skilled by these systems, that they're not just blindly deferring to them, that they continue to have skin in the game. And what I want to suggest is that this concept that comes from, for me, it's a concept I picked up from Tad Hirsch, who is an interaction designer, of contestability, I think is incredibly important. So this community has talked a lot about explainability, and you can have different feelings about it, but for me, as a parent, I'm like, well, I'm gonna tell you, here's the explanation, right? It's a one-way street. I'm going to explain, and then you please carry on. And if what we're trying to do is get the best of human and machine intelligence, we don't want to put humans in the position of passive listener, right? Of recipients of machine knowledge that will be well explained to us. I think the goal should be to design systems that both actively allow us to learn, but also dynamically allow us to challenge, right? And you can look at something like the GDPR or other things where we're allowed to challenge things out of bounds, right, or out of band. So a bad decision has come and now you can go use a court process or some administrative process to complain about it. That's important. It's an important form of contest. That is not what I'm talking about. I am talking about being able to contest within the system itself, right? Because this is the way users are going to learn about systems, and algorithms are going to improve and become more sensitive to the context and cultures in which they operate. They're also important, I think, contestability, because it facilitates engagement and reflection between the entities in shaping performance, right? That I've been interviewing legal professionals about the adoption of machine learning tools in law practice, and in some instances, I've had lawyers say, oh yeah, that tool doesn't work. And you say, well, did you communicate back? And they're like, I don't know how to communicate back, right? So like literally people are losing customers, I think, because there's no feedback loop, right? That the people who are designing the systems are not learning not just about why something isn't being used, but the reasoning behind it, right? And this requires different patterns of communication between users and developers. And lastly, as I said, it can keep skin in the game, right? That we want to make sure that the agencies that are onboarding tools continue to feel responsibility and accountability for the outcomes that are produced by their use of those tools. And if we give them tools that bind their discretion and don't offer them opportunities, not just to tinker, but to question the logic and to alter it, I think anyone is going to end up feeling distanced from their work and put in a position where they are deferring to machines rather than trying to reason with them. So I believe when we're talking about machine learning systems, contestability has to be part of our governance strategy It helps publicize the policies that are embedded in these systems. It will help avoid delegating important policy choices, even if those systems are privately developed. And it provides continuous feedback from domain experts, which means that these systems will become, over time, more tuned to the cultures and contexts in which they're supposed to serve. And with that, I'd like to thank my collaborators and turn it over to Lilian.
I'd rather hear for you. Deirdre has struggled through with no voice, so that gets an extra round of applause. We talked about this on the phone, and it's interesting because when we did, I very much had this sort of gut response that, oh my God, it's so different in the US than in the UK and the EU. And I think since we had that conversation, actually, we've moved closer together. It's really interesting because I think things have gone into your talk that weren't originally there, and also I went away and did vast amounts of research. So what can I bring to respond to this really fabulous talk? I'm not a US lawyer, I'm not a US administrative lawyer, and I'm not even a UK administrative lawyer. So I think what I can do is try to say some of the things that do stand out to me as having global differences between a US system and an EU system, and maybe just some useful examples that might bring good stuff to the table. So where are my responses? One of the things that really struck me was initial assumptions that the state agencies themselves don't have that expertise in-house, and that they will inevitably, as we have seen, go to a provider like Northpoint or so forth. In the UK, which is all I can really speak for, I think because we've started from a much lower bar and started later, and we're generally a smaller country, perhaps a more risk-averse country, there is evidence that, in fact, that agencies, the public sector has tried to develop these tools in-house. That doesn't always mean using their existing staff. It may mean working with, say, people at universities. That's quite common. One outstanding example that's worth looking at, I think, is our version. We didn't go down the Compass route to a very large extent. We didn't go down the buying the off-the-peg recidivism tool. Instead, in a very well-publicized and very well-run project, the Durham Police Constabulary worked with Cambridge University to build a system which is open to scrutiny, open source code, and which has been imbued very efficiently and very consciously with public sector values and with human rights considerations. And indeed, there's an interesting statement in one of the papers that the first thing they thought of was to start applying traditional human rights tests when they were building the tool of necessity, foreseeability, and proportionality, which are very much the routine that a court goes through when it's deciding if the state is interfering with human rights, with individual rights in a bad way, in a way that cannot be countenanced. Okay, so I thought that was interesting, and I refer to that work particularly with Marion Oswald at Winchester. There's a question which we discussed as to whether it's practical, essentially, to say that agencies should build in-house, or at least with very strong involvement and control over external contractors. And I think that led to some of the discussion we had about what the role could be of something like the US Digital Service. That's very interesting. In the UK, again, you've got some worked examples of this. You've got a government digital service. You've got some agencies such as the Alan Turing Institute, which are trying really to help to provide this kind of technical expertise so that these tools can be built within the state rather than bought in off the shelf. Then I was going to say, and I think, again, some of this has been covered, that there is a panoply of tools that can be used to achieve these goals, really, of imbuing, as it were, democratic values, policy goals into public sector systems. So, beyond administrative law, I would point at some of the things Deirdre has mentioned, such as the use of data protection law in Europe, such as the use of human rights scrutiny, such as the use of quite general principles within the law, which perhaps are the same things you're talking about, but in a less codified form, such as in Europe, things like judicial review, the ideas of natural justice, duties to give reasons, duties to provide explanations, very much what you were saying. So these have a much wider scope than just within a particular statute in the US. These are global concerns and global solutions. Okay, and maybe the last thing I'll say, where am I? Is I think there's a big issue. It's a big issue at home, and I think it's a big issue here about how far this kind of scrutiny, about how far this process of trying to make sure that public values, human rights, transparency, etc., are put into these systems and are accessible to users. How far this should be done by hard law, and how far it should be done by kind of backup guidance, codes of conduct, ethics, etc. You know, and the jury is really out on that. I think there are some useful examples of using ethics. Again, in the UK, there is a UK data ethics framework for governmental agencies building systems, which is very detailed, has 7 principles and so forth and so on. What I particularly thought was interesting, and maybe it's the last thing I should just draw to attention, is that it has a particular section on working with suppliers. So it actually anticipates that if you are an agency that is having to go out to a supplier, then you should still be trying to answer all these questions. And it has a really long, interesting list of questions, like what was the original intended use of the software you're buying in? What are the contractual arrangements? Can you scrutinize the software? Can you scrutinize it even despite any IP constraints? And it's got examples of how to do that. Can you find out how the algorithm's been trained? What data was used to train the algorithm? How interpretable is the algorithm? Has it been tested for failure? What assessments have you got for bias and so forth? So it's a really, really good list, I think. And it's very interesting that they have anticipated that outsourcing. So maybe I should hand back to Deirdre and then we'll go to questions. Sure. Sorry, that's more of them. Yeah. Less back and forth and more an info dump.
I got a cough drop, so I think my voice is a little bit stronger. So yeah, I think that there are a lot of parallels, obviously, in the law, and I think in the ways in which different governments are struggling more or less proactively. And I would say, you know, during the Obama administration, a lot of the work that was coming out of the Office of Science and Technology Policy in the White House, led by people who are at least sometimes a part of this community, was trying to make agencies aware of the biases in big data, of the ways in which machine learning models could re-encode race, et cetera. They were doing a lot of education, right? I think one of the things that we need to do now, though, is figure out how that generalized education is turned into systems that help agencies in predictable and repeatable ways reason about and understand the implications of the systems, whether they're designing them or they're onboarding them in conjunction with some sort of private party. And for myself, I don't necessarily believe that the best outcomes are if government builds the software themselves. Maybe you'll say, oh, that's a very American perspective. But it's actually just a perspective that I think most of these agencies, their core mission is not building software, right? Their core mission is serving the public in some particular way, administering a particular kind of law. And I think that there is enormous benefit to potentially partnering with and extracting and using the knowledge and expertise in the private sector or within other areas, other sectors of the government in developing these systems. So I think the question is, in these areas where the private parties are playing a very large role in public governance, making sure that all of our democratic norms that are designed to make sure that our rules and policies implement systems that align with the laws and align with our normative commitments to due process. It's important to make sure that transparency, public participation, expertise, and accountability exist, regardless of whether these systems are coming in as purchases or being built in-house. In the context of voting systems, again, I know I'm really aging myself, although there was a lot of focus on voting systems again recently, right? And a bunch of us were like, oh yeah, finally, people are gonna pay attention to that. But the exhaustion with kind of the private vendors that delivered systems that were not fit for purpose led some open source developments. It also led some counties to decide they were going to develop in-house their own bespoke voting systems. And I think any of those are fine approaches. At the end of the day, I don't care how we get it. I care that it's consistent with our normative commitments. And we should be able to make sure that's so regardless of who's building the software. And we just need to pay attention to incentives. So we're going to open it up for questions because we felt like there hadn't been quite enough time for questions during the event so far. And questions for either of us, obviously.
Hi, my name is Annika Goldman. I work for a startup called Canopy. My question is that I think there's a policy choice in choosing whether or not to use a machine learning system at all. And my understanding of your proposed interventions were that they were assuming that that choice had already been made. And so I wanted to understand if you could speak toward that a bit.
Yeah, no, I in the beginning of the talk, I said, one of the things is like whether or not this is the right tool for the task to begin with. And no, I wouldn't presuppose that a machine learning system is the right tool for whatever task. And there's a long history of the private sector developing, the latest widget of the day, and it could be RFID-enabled passport. Like I could give you a whole litany of technologies, and the driver is often, we have something to sell. And we are going to identify your need for you, right? And then tell you that we can satisfy it. And so I think, part of the deliberative process, and you can see that also in things like privacy impact assessments, where they're not just supposed to provide feedback on whatever design the agency is proposing, but they're also supposed to think about alternatives, right? And so, no, this doesn't just kick in like, oh, you want a system, now start. No, this could kick in earlier.
Great, thank you.
Yeah. I can't move the mic, so you're going to have to.
Go ahead.
Oh.
Hello, my name's Eric Corbett. I'm a PhD student here at Georgia Tech. And this was a really interesting talk for me, especially because our program, digital media program here in Tech, we do a lot of research on how can technology improve modes of public engagement. So using technology as a mode of participation, so digital democracy, civic tech stuff. Through that work, we often run across the fact that our existing modes of participation are not necessarily doing what they're supposed to do, or people aren't able to participate in the ways that they should be able to. And if you look across, democracies across the world, like from Brexit to what's going on here, right? Like our existing participation mechanisms don't seem to be working the way we would like them to work. So I think it's interesting as a start to apply these things to, these new systems, but in the back of my head, I'm thinking, oh, well, these existing things aren't really working, and now here's this new really complex stuff, and we're gonna apply it to this. So I guess my question is, like, where do you see if anything, like the fundamental breakdowns in like existing modes of participation and how they might be, how we might need to change them or think differently about them in this space?
Do you want to say? I have stuff to say, but whatever.
Okay, sorry, I don't want to take your time up. No. I actually have things to say about that. It's funny, I had them, I didn't get time to get to them. I think there's two really interesting things going on there, at least from my knowledge. One is your preliminary impact assessments, if we're going to go down that mode. How public should they be? We talked about different models of internal experts, external advisory boards, town meetings, all this sort of thing. What's going on with sidewalk labs in Toronto is an interesting example. I feel strongly strongly that these things should be open to the public, they should be enabled to the public, and that the results should be published. Because even if you go to privacy impact assessments under the GDPR right now, the General Data Protection Regulation, it's not actually required they be published. And it's hard to see if many private sector companies will do that. And the other thing I'd add in, which I think is a really interesting difference between at least the UK and the US, is how do you find out what's going on afterwards? How do you find out if your participation's been enabled? Because in the UK, you can't get a freedom of information request against a private outsourced contractor, right? And this is under some debate right now. I'm very curious to know how they deal with that in the US, but I think there is a real issue here about access to know that what you said is being carried on.
So FOIA would take a very long time to discuss. There are exceptions for trade secrets and business, right, and which is similar to what you have, but just because there's a private sector involved doesn't necessarily mean you can't get access to anything, but we can, that's an offline.
You're a better role model on this, I think.
So the question about can we use technology to actually improve public participation, transparency, and deliberation, and kind of the expertise in public processes is one that people have been asking for quite some time. Cornell for some time, I don't know if it's still, they had, it's called the Regulation Reading Room. There have been other folks who've had efforts to try to make it easier. So any of you can participate in an administrative proceeding, right? If an administrative agency is adopting new rules, you could think, I bet some of you participated in net neutrality debates, maybe you submitted comments to the FCC, right? You didn't need to be a lawyer, you didn't need to have any kind of credential, you could just participate. Now, of course, just because you can participate doesn't necessarily mean that it's easy, right? That those documents are very long, there's lots of technical language, and there've been lots of efforts over the years. Organization that I helped start, the Center for Democracy and Technology, one of the earliest notice of proposed rulemakings about the internet, we actually created a nice interactive form that tried to take the questions that were being asked in the NPRM and reduce them to something. It was like short notices for agency statements, right? Trying to help the public participate, and also provided the information back to the agency in a nice structured way so they could look at all the comments about issue 2 instead of having to read all the letters and figure out where issue 2 was discussed, right? So using technology to both help participants and also help the agency, because agencies end up bombarded in some instances by an enormous amount of public participation, and there's a lot of ways in which technology can actually help them manage the public input. And I think that there's been more efforts on that side. But I think at the end of the day, people often say, democracy sucks, except then you look at everything else. And yes, it's not working perfectly, and I think that there are ways that we can make it work better. But with respect to kind of policy making and administrative agencies, there are lots of opportunities, if it is viewed as policy making, for the public to participate, and for nonprofit groups that represent interests such as civil liberties or civil rights, or et cetera, to participate. So I think we should use it and critique it at the same time.
You've got half a minute. Do you want to take one more question?
Sure.
Thank you so much for your presentation. My name is Tanya Krupi. I'm a researcher at Tilburg University. And I really like your comment about public participation. And I'm curious what you have to say about how the public can actually be prepared so that they can engage effectively in the process. So from my perspective, I have a doctorate in law, and I started to work on data science. And I actually realized that the way with which I am being presented with the material can influence how I understand data science and what gaps I see. I talk to many computer scientists, and I get a very different impressions of this technology depending on who I talk to. And I think this conference actually shows us that even people with doctorates can, there's a lot of debate and understanding to be had before we actually understand artificial intelligence and are able to critique it from many perspectives. So my question for you is this: how can we actually put the public in a position where they can have an informed debate and where they're not swayed by the way in which they're being taught about data science? Thank you.
That's a there's a role for educators, and there's quite a push right now for data science curriculums to include attention to the social and political impacts of technical systems. At Berkeley, we take that really seriously, and I think it helps develop data scientists, technical people who have multiple competencies and are both more able to talk in a meaningful way with people in the public and outside their disciplines. So that's certainly one piece of it. There are areas where it's really important that the public have its own experts, right? And in many ways, that's what agencies are supposed to be. But it may be, in the US we had something called the Office of Technology Assessment, which was a very small advisory group that provided advice on science and technology matters to Congress. It was done away with during the Gingrich Revolution and the contract on America. It's called, not for America, it was on America. And we need more sources of public expertise, because you're right, the public needs to have people it can trust, and it needs documents and information that are both accessible and accurate. But I don't think there's a silver bullet.
God, there's so much I could say to that, but we're being trivial to stop, so let's just have another round of applause for a wonderful talk.